Hi, everybody. I'm immigration lawyer John Robbie. Thank you for joining us again today. It is, what is the day right now? It is January 10th, 2023, our regular Tuesday to 5 p.m. Pacific time, where we jump in and talk about U.S. immigration law. Take your general questions, educational stuff about the U.S. immigration process on LinkedIn, on Facebook, on YouTube, on Instagram, on TikTok. We're all over the place as your questions come streaming in. We're going to get to them and just help some general stuff. Now, sometimes there's rapid fire and answers don't get fully answered, so we do our best here. Again, it's general education. You should talk with an immigration attorney in private about your case so you can really dive in deeper and have follow-ups with them. But we'll do our best here to touch up on a lot of stuff that are happening within the immigration field. Go to look forward to doing that. We have a lot of regular listeners and new ones. For those who are new, we do give away, just to let you know, we do give away free video consultations for those that watch the live show. All you got to do wherever you're watching this is, either write a good question, or if you don't have a question you want to have publicly, write consultation, like and subscribe. Only say it once. Please don't put on repeat. But say it, and every 10 minutes for this 30-minute show, we'll announce winners of the free consultation raffle, which is 15 minutes free video consultation. We can talk in private about your case and take it from there. Secondly, if you haven't already, you're interested in learning about immigration, particularly marriage and fiance-based immigration, the first thing you should do is go to marriageimmigrationlaw.com and download the ultimate marriage green card guide I wrote, 40 plus pages of intense and detailed information about the process. Again, the website is www.marriageimmigrationlaw.com. Go there and you'll have a good go at it to learn the basics of the process. And having said that, let's get the show started. So Melvin says, good to join now. Melvin, thanks for joining. I appreciate it. Next question, Mehmoud says, if F1 convicted, can he apply for OBT? I think you're a student visa holder. You have some sort of conviction. Can you apply for OPT? They don't get into conviction and stuff for OPT, so it may be possible, but it depends on what the conviction is for. If you got convicted for a speeding ticket, yeah, that's not a big deal. If you got convicted for killing somebody, then it maybe you have bigger things to worry about than OPT. So there's not enough information about the conviction. I need to see the record of what's going on to see if there's wider immigration issues, not just related to OPT, which is OPT is if you have a student visa, you could work in the United States in the field of study for 1 year at least, depending on what you studied, so you get on-the-job experience. So it really depends on the facts of your case and what's going on there. We have another question on Instagram. Alex asks, are you going to move to more online filing since USCIS will likely increase filing fees for paper filing? So this is a really important question. And the process, this is annoying for me as an immigration, not your question, but what they're doing is there's going to be a serious fee increase with USCIS for their case. So be prepared. Next 2 or 3 months, you're going to see a massive increase in filing fees with USCIS. So if you have a good case that you could file now, it's probably better you do so. One aspect of it is they're increasing fees, but they're giving some sort of discount or lesser increase for cases that are filed online. So if you file online, it might be a little bit less expensive. Typically, most immigration lawyers do not like filing cases online because the system is not as smooth, and we just feel more reliable with a paper-based system because when these new technologies come, a lot of times they make mistakes, it's a headache, it's hassle, so we don't like to use them. However, because the filing fee for the online cases are going to be less, our clients are probably going to ask us, hey, could you do it online? And so we're going to pick and choose depending on stuff. So it's various things. Some clients don't, part of the online system, if an attorney completes it, we have to ask the client to log in and do some extra work to finish the process and to review stuff. And a lot of times, at least right now, I'll feel better in the future, but our clients are not comfortable with the online system, reviewing it, signing what they need to sign, all this kind of stuff. And it creates a lot of headache. So it's just easier not to, because it creates so much time and difficulty for the client to fill out the online form. And then there's other times where you're doing a case like a marriage adjustment case in the United States. This is when you get married, or essentially a relative case where you're also filing Form I-130 along with adjustment of status Form I-485, these two applications together. The Form I-130 is online. You can submit that. The Form I-485 is not. So if they want to save money, they'll file the online I-130, get a receipt, and then submit the adjustment of status with that. So the files essentially get separated. I don't want to do this where partially the application is uploaded electronically, partially by paper. So we're going to tell our clients, it's mandatory if you're going to do a combo case like this, I-130, I-485, we're going to say you have to do all of it by paper. But yeah, we are going to be forced to do this because, I don't want clients to pay more, but they're going to be prepared. Maybe the attorney fee goes up because the back and forth we have with our clients to try to get the online case done takes more attorney time. So in the end, they're probably going to not save money by doing that unless they're really smooth. So we're going to start testing it out and do this kind of stuff. But inevitably, everything's going to go online for better or for worse. Good question. Thanks for asking that. We have another question on Instagram. Malik asks, getting sued after a car accident, is this going to be a problem with getting citizenship? Well, getting sued itself isn't per se. It depends on what the lawsuit is. If they sue you for intentionally hitting them, yeah, that's going to be a problem because that's a crime. But it depends on what it is. Typically, civil actions like lawsuits and stuff are not a problem unless there's accusations of fraud or your moral character as a person comes into question. So if you got into a car accident, that doesn't mean moral character. Everyone gets car accidents and stuff. But if you got in a car accident and then you start to hit the person or there are accusations of some sort of criminal activity or over-the-top activity, maybe that could. But typically, a simple car accident is not something that's going to be problematic for your green card case. Okay, you're welcome, Malik. So let's go back to your question. Other stuff. Zoe asked, while working for a U.S. company as a consultant, can I visit the U.S. on a tourist visa without problems? You can. Now, you got to hedge this and to the fact that it always depends on the officer at the airport that you're dealing with, how they're going to deal with it, if it give you hassle. But typically, if you're coming on vacation and not working, then it's not a big deal. But if you're going to be working too for that company while in the United States, unless it's something like, on training there or some sort of conference or something you're going, the risky maneuver to do. But if you're purely coming on vacation and you're not going to be working, it shouldn't be a problem. But it's not up to me here. It's up to the person at the airport that's going to stamp your passport. Well, they stop stamping it, but it's going to process you in. But if you're just, again, coming on a tourist visa, it most likely is not going to be a problem. Kamran asks, if someone's ESTA got denied due to immigrant intent, what's the next step? How long do I wait to apply for B2? So let's back it up and explain to people what this stuff is. ESTA is a special program for people from certain countries with certain passports where they can visit the United States without applying for a full tourist visa. They go online, they fill out an application, and they have the permission to come for 90 days in the United States and go back. Now, at the airport, like the last case, if they question you about working in the United States or question your intent, say you're actually to come and stay and not go back home, they could send you back home from the airport. I just had a consultation this afternoon about someone that this happened to. So let's say they come to the airport, they think you're going to stay. It's not a temporary trip. They send you back. That cancels out the ESTA, that rejection. And if you want to visit the United States, now you have to get a full-on visa. It could be a tourist visa, it could be a work visa, whatever it is. But how soon do you wait if you want to come visit and ask a B2? There's no answer to that. You could file immediately. You could wait forever. All it comes down to is when you go to the embassy interview, you have to be able to explain to the satisfaction of the consular officer what's the important need that's pushing you to come to the United States and what background do you have. Usually if they deny you on your ESTA for entry, it's because you've been spending so much time in the United States, they start questioning whether you're actually living here or not, or if you're maybe working here, if you're here so much. How do you support yourself? So if you have answers for this and a need for it, maybe that's the tourist visa will get approved. There's no how long to wait. It really depends on the facts and why you need to come and how you can express and prove that to the consular officer. And so that's what you got to be thinking about. Boss Nation asks, can my stepkids still come to U.S. if I get divorced in their cases at the National Visa Center? So I'm guessing by stepkids, you're the stepfather and your stepchildren from, let's say, your ex-wife are there. They're stepchildren because you were married to their mother before their age of 16, which allows them to be part of your case, and you had a case filed for them. It is possible to continue that kid at that point, even if you're divorced. It's a special part of the law, but you have to show that your relationship is remaining after divorce still. So it's still possible, but again, you have to show that the relationship remains between you. A lot of times we show personal support, financial support, day-to-day activity, calling them, emailing them, proof that you're handling them as your children, and that could be a reason they could approve it based on being a stepfather case. It gets tricky, something you should talk to a lawyer about, but it's not impossible. Aframax says, can a person with a green card petition for family members even if they have lived 20 years in America? So the word petition is particular. The petition is from I-130, and yeah, you could petition them. But for them to actually get the green card through adjustment of status or consular processing, that becomes problematic because they've overstayed. It seems that they're here for 20 years without, if they had, let's say, assume, and I'm guessing, they don't have proper status. So if they're at a status and they've been living in the United States, they can't file for adjustment of status in most cases. But let's say you're a U.S. citizen, you're applying for your parents, that's possible. If you're a green card holder, if they're like brother or sister, that's not going to work out. So it depends on what the family relationship is. But if they go consular processing, that's a good problem because they're going to be subject to what's called a 10-year ban. So they can eventually get the green card, but they got to be outside for 10 years. So it's not impossible, but there's a lot of things you got to do and be prepared for in this kind of situation for it to work out. Now, I want to announce our winner of a raffle, my wonderful assistant, Katrina, named Boss Nation. If you're still watching, take a screenshot where you're watching this so I can see your username. Email it to me at info@jqqlaw.com so I can respond with a free video consultation, Boss Nation, and we can talk in private. For those just tuning in, we give away free video consultations. All you got to do is like and subscribe and ask a question or write at the most consultation in the chat box and to let us know that you're interested in having a consultation. And from there, we'll name someone off in 10 minutes and 20 minutes as lucky raffle winners, and we could take it to a private video consultation. For those interested in marriage and fiance cases, we have the Ultimate Marriage Green Card Guide. Go to marriageimmigrationlaw.com. That's www.marriageimmigrationlaw.com and download the Ultimate Marriage Green Card Guide to learn all the basics of the marriage green card process, fiance visa process, all that kind of stuff to help you out on your quest to get the green card. Next question, Emma asks, hey, I'm a little confused. At what point do we file for adjustment of status? We're already married just within the 90 days that I land and plan on moving. I can't get too much into detailed 90 days and stuff, but if you came to the United States and you married a U.S. citizen, you could file for adjustment of status at some point if you change your mind and decide to stay here. If you're a green card holder as possible as well, you got to be in status at the time of filing. If you enter and quickly file for adjustment of status, it might look like you actually intended to file for a green card, not coming on a trip. You falsely claim to be on a trip, so that could be problematic. You want to be careful, make sure your intent is clear. But if your spouse is a green card holder, you got to file for adjustment of status within the validity of your I-94 period. At the time, it could be in the United States. Spouse of a citizen doesn't matter as much. But there's a lot more to this conversation, Emma. So definitely schedule a private consultation. We can talk about that. Salimas, I got married in the United States. I'm Canadian, and U.S. Customs refused me port of entry. My I-130 is pending. Oh, that sucks. So this kind of case is something they're worried about, that you're coming to the United States on a tourist visa with the intent to file for a green card. The previous questioner had this kind of thing. This is the worry. You got refused that entry. We got to see what kind of refusal it was. The soft refusal, which is called voluntary withdrawal, but they just said you can't come back in. Or if they give you expedited removal, which is a deportation, which could lead to a 5-10 year ban or something like that. So you want to know which one it is. They should have done an interview with you and given you a transcript of it. But you could try coming back again if you didn't get expedited removal. But more likely than not, you're just gonna have to wait now for the I-130 to be approved and then go through the National Visa Center process and eventually have your in-person interview in Montreal. So you're probably looking 1 or 2 year more waiting, unfortunately. But that's kind of stuff you have to look forward to in this kind of scenario because they're afraid you had immigrant intent. You're going to come just stay here and not go back to your home country because you have a spouse and you have a green card case that's already pending. User 6 says, what should we do if the form I-864A is being rejected? How do we know what information is missing? I'm guessing you're dealing with a consular processing National Visa Center. A lot of times they push back on this form. I have to see and review the form to see what it is. So it's not one of those things I can't just tell you. I have to read it. But the problem that you have, and for other people to know, is when you're dealing with a National Visa Center at the embassy, not the embassy stage, but before you get to the embassy, there's a group called National Visa Center. They review the documents, and if they find a problem, they say there's a problem. But most of the time, they don't specify what the problem is. And at this point in our firm, when we do get this, almost every time, they're making a mistake and they're not clarifying to us. We have to complain to a supervisor review to catch the error. The problem is when these errors happen, it just resets the clock on the case time like 2 or 3 months. So it's pretty catastrophic when it does happen. And particularly it's worse when you're dealing with form I-864A, the affidavit of support for a household member. They do not understand this form many times and they get confused. What I've seen is almost like most of the time I could get away with not sending this form because we could get the paperwork right, but they'll request it. And when there's other times when we need this form and I submit it to them, They challenge and say it's not needed. So it's a complete mess when you have to deal with an I-664. Ideally, you don't have to, but have an attorney review it in private to see what's missing, and maybe you're right and they're wrong. You just have to clarify it with a supervisor there through the embassy portal to message them. That kind of stuff happens a lot, unfortunately, with the National Visa Center nowadays, and it's a nightmare to deal with. 3681 says, what is the process like for someone who overstayed and won the diversity visa lottery? There is no process. You're not allowed to adjust status if you overstayed on the visa lottery. If you leave the United States to do the processing through the embassy and you've overstayed for more than 6 months, you'll be subject to a 3 or 10-year ban. Essentially, the diversity visa lottery is worthless in this case. There's no point in filing if you have overstayed. It's not going to do anything for you, unfortunately. Sorry, you won, but you still lost on that one if you overstayed. Now, side note, if you do have a qualifying relative, you have a parent that's a citizen, green card holder, spouse, maybe you can file for a waiver, but getting a waiver approved takes 1 to 2 years right now. So practically speaking, it wouldn't work. Sue asks, hi, John. I got documented, qualified almost a year now, but my priority date is not current. My elderly mother petitioned me. Is there anything I can do about to receive it sooner? I live in Canada. I do not have expedite request letter. There's nothing, unfortunately, you could do, Sue, to push the time forward if the visa bulletin is not current. So essentially, depending on what category you are, here it's either a green card holder or U.S. citizen applying for their daughter, adult age daughter, and there's a line for that. And there's no way to speed up that line. That's something that's limited by the number of green cards available every year that are issued by the United States, and those get used up quickly. And that line recently hasn't moved at all. It's been a year or so in your category where these things have not moved up. One quick note on TikTok: if you can't ask the same question over again, if you do, we're gonna have to undo you. Unfortunately, let me sorry to do this. Please stop. And sorry to cut your question short, and it's for editing. This is going to be annoying for people to see this, but it really throws off people to get the same question over and over again. We'll have to kick you off the channel. But having said that, the line for the visa bulletin doesn't move up, and unfortunately becomes a big problem. And it hasn't moved more than a year now. It's catastrophic. The F3, F4 category just stalled. So there's nothing you could do, and that's about it, unfortunately. So I don't have any good news there. Tiffany asks, can a criminal record be waiver? I think you mean waived. It depends on what the criminal record is. So we need to know details about what the charge was and what the conviction was, what the facts were behind it, to see if it's something that could be waived. For example, if you're a drug dealer selling, millions of dollars of drugs, no, that can't be waived for a green card. Potentially, you could waive it for a non-immigrant visa with a Haranka waiver, but for a green card case, that can't be waived. But if you have some drug use more 10 years ago, maybe that could be waived. It depends on what the actual record is. Just telling me criminal record doesn't help me be able to answer that question. It's something you should talk on with private with an immigration attorney. Okay, please stop. Always remember, don't ask the same question. We just want to answer your question. If you keep spamming it and repeating yourself in the feed, it makes it really hard to do this. So please don't spam the line. All right, BK Pun says, if my marriage-based green card is denied, can I change status through my university or through work sponsorship through employer without leaving the country? So there's some problems here. So one is, why would it be denied? Your marriage-based green card is denied because they said the marriage is fraud, and you have a fraud accusation. You're out of luck. That's really bad. You have to challenge that. Secondly, there's no change of status through your university. If you're here on a student, the student aspect doesn't go to green card on its own in any way. Through work sponsorship, you might be able to do it. Again, you have to maintain status and to be able to apply for these. There are some exceptions for maintaining status, but this is a really complex situation, BK Point. If you want, my assistant Katrina said that you're a winner for our second raffle. Take a screenshot where you're watching this and we can talk in private, because without leaving the country, you need to maintain status. And so it depends on what the marriage denial is based on, what kind of status you're going to get, how quickly you can get it. For example, a green card based on employer right now is going to take a year and a half, probably, or at least a year, for you able to file it for EB2 or EB3 category. And your case has to be current for you to file for adjustment of status. So you have to maintain status till that happens. As I'm talking about this, it gets way too nuanced for this general counsel discussions we're having here. That's why it's best to talk in private for this, and you want to raffle BK Pun. For those just tuning in, we give away free video consultations. All you gotta do is either ask a good question or just write a consultation, like and subscribe. My assistant will name off somebody. We have one more free consultation to give away in 10 minutes, and we'll do it there. I have a question on Instagram. Adam says, if you were married since 2020 and have a 2-year green card, can I apply for citizenship 2023? If you were married to a U.S. citizen for the last 3 years, that may be a possibility. There's other factors you have to take into consideration, but that may be something you could do. But again, you have to be married with a U.S. citizen during that time. NK asks, what to do if immigration visa gets refused before going to the interview? I'm not sure why your immigrant visa would get refused before going to the interview. That's not a typical thing to happen. So you definitely need to talk to attorney in private to see what's going on there. That's not a typical thing. Melvin asks, NBC wrote to me that they received my approved immigrant visa petition from U.S. citizen. Please, what should I do next? In the email that they send you, they explain what you got to do next, which is, log into the CAC site, CEAC, pay the fee, upload the necessary civil and financial documents, and also fill out Form TS-260, and then wait, if that's approved, wait for an embassy interview. It's all in the welcome email that they sent you. It's also in my guide, marriageimmigrationlaw.com. Go to that website, down the Ultimate Marriage Green Card Guide. Even if it's not a marriage case you're doing, that portion is redundant, so it'll cover you in that situation as well. Yeah, you got to do consular processing. So I have a really detailed video on this. If you go to JQK Law's YouTube page, it's called Immigration, U.S. Immigration Talk, or JQK Law. It all pops up. And so type in JQK Law and type in consular processing. I have a 15-20 minute video where I detail the whole process. Dabby asks, I came from Mexico. I'm from Europe. I seek asylum. Can I get married? And when I sent I-529 form, to be able to marry in the United States to get a green card, you will need to have entered with parole or some sort of admission. I don't know the details of that, so I don't know if it's possible or not. And a spouse has to be a U.S. citizen if you haven't maintained status. So there's a lot of different factors that we got to look at there, Dabby, before I can answer that. Mayat says, I am from Burma. Can I apply for humanitarian parole visa if I don't have a valid passport? My brother-in-law is in the U.S. and non-immigrant visa holder. Can he sponsor me if he is not a green card holder? So for humanitarian parole, I'm not a big humanitarian parole person. Usually you have to have a valid passport to enter the United States. They may make an exception on it. I don't know if you get away with not having a passport or not. I don't know the details of all these humanitarian. It's not something I typically do myself. Someone else in our office does it. So I don't have any good answers for you on that. Rostam asks, how long is I-693 valid for? Once submitted with the I-485 application, it's valid for 2 years right now. Yeah, it's even more because of COVID, but the standard is 2 years for the doctor's signature. Allah Sensei, hi John, can you do the medical exam while waiting for a visa interview? No, if you're waiting for a visa interview at the embassy, they want you to do the medical exam like a few days before the interview, so that's best to do it that way. And the length of your visa is, unless there's exceptional circumstances, it's like 6 months after the doctor's appointment. So the later you do it, the better. It buys you more time on the visa application. In some cases, if you have, for example, a false positive for tuberculosis, they'll only issue the visa for 3 months. So you want to make sure you have that extra time just waiting near the end, unless there's a reason that you're worried about it. A lot of the doctors won't see you. And the reality is doctors require that you have to have the immigrant visa appointment date already figured out and a notification from the embassy before they will even schedule the appointment. So there's no point in trying to do what you got to do. You got to wait for the appointment to be scheduled. Mary asks, I filed the I-130 in 2021. Documents are approved at embassy, but no appointment date. How should I proceed? If your documents are documentally qualified with the National Visa Center, you got to wait until the embassy notifies you. Zeddy asks, hi, my husband has 2 entries, but one when he was a minor. Is he eligible? I'm a citizen. If he entered twice, and he might be subject to a 2-year bar, and there's no age limit on 2-year bar. So if he entered, overstayed for a year, left, and then re-entered again without permission on both tries, then he might be subject to the 10-year bar, which means he has to leave the United States and wait 10 years before he comes back in and asks for waiver and all this kind of stuff. So this is something you definitely need to talk to a lawyer about in private. Mark Pick, I think you're one of the regulars. I wrote a letter of misconduct to his supervisor about an officer interviewed us. The officer knew that we are a real couple, but tried to fail us anyways. What could possibly supervisor do? I don't know. I don't know the internal bureaucratic stuff. I mean, people could get fired potentially, but I don't have information at what they do with stuff. Probably nothing, frankly. Edward asks, I applied for I-751 in summer of 2021. End of November 2022, I applied for citizenship. They transferred my I-751 to NBC. Should I expect combo interview? I'm applying for NBC. I don't know. There's no expectations. They're going to do whatever they want to do. So you just wait to see what happens. Joseph asked, first minor drug offense, rehabilitation relief for immigration. Is it a problem? I need to know exactly what the minor drug offense was. It depends. If you have a minor drug offense with cocaine, it's one thing. If you have possession of marijuana, like a gram, then may be okay. So it really depends on what the situation is. Just saying minor drug offense, first time rehabilitation, it doesn't provide me enough information to answer that. Keon asks, do you know if staying on military order in Germany is considered part of 2-year stay requirement for CR1? 2-year stay requirement. 2-year home residence requirements for a J1 visa. So for CR1, conditional relative, there's no stay requirement. It's just that you have to file for a removal of conditions after 2 years, Keon. So I think you're confusing two different things that are in there. So I'm not sure exactly what I'm talking about. For the I-751 removal of conditions, you don't have to be living in the United States the whole time. It's not mandatory. They even have it in the policy manual, but it's better to do that for other reasons. But it gets a little deeper than we can talk about here. So your question confused me a little. It might be a little bit off, but that's that. Thanks for your question. Does a U.S. citizen spouse have to wait for a visa to be available? No, U.S. citizen spouse are immediate relatives. They're not part of the visa bulletin preference category, so they don't have to wait for a visa to be ready. Okay, I'll skip this question. Unfortunately, there's nothing I can do there. Jenkins says, NBC approved all the documents, waiting for a long time to get an interview. Is there a way to expedite? If you have a reason to expedite something urgent, you could contact the embassy and ask them. They may do it. It really depends on if they want to do it. NK says, thanks. Nick says, does waiting time for I-751 depend on the state you're filing? No, it just depends on when they get around to your case. Brittany says, will it hinder the K1 visa if me and my fiance get married at the embassy in Nigeria? Well, first of all, you don't get married at the embassy. You just get married in that country. But once you get married, it invalidates the K1. K1 is a fiance visa. And if you're not a fiance anymore, you're married, then that case disappears. So may not be, if you've been waiting for the K1 to be approved for a long time, may not be a smart idea to get married because it's going to be a waste of waiting for the K1 and the money spent. Neval says, is Texas Service Center fast in processing? They're all different. Ryan says, if I'm here on a work visa and I change companies, how hard is it to change my visa? It depends on what kind of visa you have, what your background is. For example, if you're on an H-1B visa and you're moving to the same or similar job elsewhere, it might not be too hard. The new employer has to pay filing fees and submit something. So how hard, well, will that employer be open to helping you with that, or they'll be difficult with it? That's one thing. Now, if you're on an L1 work visa, that's going to be extremely hard because you have to transfer to a same or similar, another job that's related to your foreign company abroad. And that's going to be hard if you're leaving the first job unless they're transferring you from one branch to another. So it really depends on what kind of work visa you have. Is it an O? If you're on an O visa, you got to file an amendment to amend your itinerary. It's not something with this basic information you gave me that I could answer. So you really got to talk to the attorney private. Edward said, is it true that the M400 application are priority now and they schedule your last 6 months? M400 applications are generally a priority in general. Do the interviews 6 months? No. No, that's not true. Sometimes do, sometimes they don't. Melvin says, thank you so much. You're welcome. Sandy says, how do you report a spouse who just used to get you for the green card? I don't know that. There's go to USCIS.gov to get information on that. I love my kid says, I passed the interview today, but I changed all my 3 names. They gave me a letter saying decision cannot be made. Your application, yeah, what does that mean? It means that they got to think about your case more. That's about it. You haven't passed your interview. That's what that actually means. Apple says, how easy is it to renew H-1B the first time renewal in Canada? It depends. Have you been, doing criminal activity? Has your job changed? Is there questions about your educational credentials? It's all relative. So we just got to see what's going on there. Lisa asks, does the USCIS check if the U.S. sponsor owes extreme amounts of child support? Not typically, but I've seen random stuff like them doing stuff like that, but not typically. One thing that does happen if you owe extreme amount of child support is they invalidate your passport, but you may not. So typically they don't, but who knows? This stuff with USCIS might pop up. Zachary says, would a wedding ceremony planned for 5 months out from today have a case to get their marriage-based green card expedited? It's been over a year since USCIS expedited submissions. No, you can always give it a shot. It's not 100%, but very unlikely. Hope Domingo said, get deported, do you have to file I-601? Maybe you might have to file a 212 as well. But I-601 happens after you file an I-130 approval. So If you're deported, you got to talk to immigration in private. It's not the place to talk about that here. Why do persons get denied a tourist visa on a 214B? Because the embassy either thinks you're going to come stay here and not leave, or they have other reasons they want to deny the case, but it's less paperwork to accuse you of 214B, so it's just easier to deny you on those grounds. So thank you everyone for asking these questions. We're about ending the show. Our third winner of our free law consultation. There was someone. Is there anyone here that we could give it to? I'm sorry. So Carmen Eloanora, he said consultation. Please take a screenshot while you're watching this so I know it's you. Email me and briefly describe the immigration issue that you have so I know like what to prepare for, because some office doesn't handle every case. I want to make sure it's something we handle. But take a screenshot, email it to me at info@jklaw.com. For those just tuning in, we give away free video consultations. We're out for today, but we give away 3 every week. Just come back next Tuesday at 5 p.m. Pacific time. We can do it. If you want to schedule a private consultation, just email me at info@jklaw.com. Briefly describe your case or issue, and we can set up a time like that. Having said that, God bless you already. Thank you so much. I'll see you all next week. Till then, be safe.